Greetings, my noble family. It is I, your King, Clifford Jefferson, reincarnation of King Edgar the Peaceful, known as Jesus Christ. Also, the establishment of the government established by Godfrey the Fifth Kind of Man Jew, son of Folk, ruler of Jerusalem. I'm here with my significant other, my queen, my goddess, Sister Godwinson from the House of Godwin. I'm here with my counsel, Archbishop Mount from the House of Belmont, C.A. Core Judah from the House of Murphy, as well as those who are striving to be the trustees of the King's Bench on behalf of the heirs and successors who are the beneficiaries. I have along by my side Sister Allen from the House of Allen, Sister Walker from the House of Walker, Brother Gray from the House of Gray, Brother Militant from the House of Militant, Brother Scott from the House of Scott, Brother Earl Esquire from the House of Esquire Burgess, as well as, who else I got up there? I know I mentioned somebody. That's it? Wow, one shot. That's what I'm talking about. Greetings, my noble family. It's always good to see you here, paying your contribution to the English Third Temple Church of England, incorporated at the English Third Temple Church of England, King, heirs, and successors. We love you all. The church loves you, and thank you for worshiping as required in regards to our bylaws. It has been a truly beautiful Sunday for us, for it is a Sunday where we're removing this cloudy title off our estate. We know that the cloudy title was established by a program system known as land banking system and funded by funding money, which is the violation of the Currency Act of 1764. Established for the preservation of our estate, which encompasses the assets which were considered the medium of exchange at that time and era when we did our business. But our business has gone undissolved as a result of the institution of the funding money, which is a monopoly as established by this article by Edward Quentin Keesby, which was the attorney in New Jersey, in Southern New Jersey, in regards to illegal trust set up by these land banking systems in regards to the land which belongs to heirs and successors based off of trust, which is intel and not fee and simple. So it's only by this information that we'd be able to take our vast estates from these corporations in lieu of those that were mentioned that has quadrupled in lieu of the acquired debt that they assume to have, which we know that was required a pre-debt that was established by those who preceded them. So we're here today to establish once and for all that we have come for ours and everything that belongs to ours that were left from us by the grantor, which is the king. When we say king, we mean English kings and successors, English queens and successors. We come for our own and only our own. This is truly a magnificent lesson given by the King's Bench off the auspices of I, your king, and I desire that you all take heed to what's being said, that because it will be your duty as well to follow the steps of the king in lieu of trustees as beneficiaries, as well as trustees to the beneficiary obligatory duty that you got to those beneficiaries who are not here today, but soon to come on upon the scene by way of this enlightenment truth that we have. So I thank you all. I hope that you all see the beauty in this lesson. We don't claim to be, the wise and, the deeds and the thou. We just claim to be English men and women. And, the information that we have pertains to that, which essentially our claim and our birthright pertaining to our political status and allegiance to our ancestors who were kings of England, Ireland, and Scotland. So once again, we're here with a beautiful lesson. My queen is here as always. Okay, my queen is here as always, and we come to break bread with you all in Clifford's Zen. So without further ado, let's get started. As Sister Walker has read, Sister Allen read that, right? Or Sister Walker?
Mm-hmm. Sister Allen.
Sister Allen read in lieu of that it is the truth New Jersey is not the only state in which these large corporations have been formed. There are others which have offered great inducements to the formation of such companies. West Virginia and Kentucky have for a long time afforded special facilities for the creation of companies intended to do business in other states. And Delaware has lately entered into active competition with others. Now, the reason why this is very important, because as we can see in New Jersey, there's an article by the Governor Murphy, who's supposed to be, if you look on Wikipedia, he's supposed to be a royal governor of New Jersey within the jurisdiction of Great Britain, as it says on the website. But here you see that he's playing two roles. He's okaying or permitting the acts of land banking to be practiced in the territory known as Newark, which is a particular territory in New Jersey. And it says here, Newark Governor Phil Murphy today signed New Jersey land bank law, which will allow New Jersey towns and cities to designate a land bank entity to obtain vacant, abandoned, and neglect properties for productive reuse purposes. Okay. This law will provide municipalities with a tool to revitalize and reuse properties for public benefit. Now, we know this falls in it because it does not include those who are identified as nickel blacks because they're Ethiopian, because it was created to segregate you from this type of benefit created under the land banking system, which is funded by funding money. Because as heirs and successors, you already got something in place for you. And it's going to be kept on the low until you understand that history, which pertains to reclaiming that birthright by, as I said, becoming trustees to administer the assets to the beneficiaries as required by law, by operation of law. So here you see Governor Phil Murphy signing legislation to permit municipal land banking. But as we read under the statute 1-6, that the classification and arrangement of the several sections under Chapter Title 48, which deals with land banking, were only made for the purpose of convenient references in orderly arrangement, and therefore no implication or presumption of legislation construction can be drawn therefrom. So how is he doing it based off legislation when it just clearly shows you that the legislation authorizing land banking system is not legislatively constructed? So what type of legislation is he using? Does that make sense?
Mm-hmm.
What type of legislation is Governor Phil Murphy using to qualify the Just Act in lieu of land banking system? There's none. There's none. But it's going to fly. Why? Because there's no one to challenge that claim.
Mm-hmm.
There's no one there to do it. All right? So that's what we're here for. Let's go back to the article. All right. Brother Gray. Oh, you still at work. I'm sorry. Who else can I call upon? Brother Siak.
Yeah.
Pick off where Sister Allen left off. She left off right here in New York and many other states.
New York and many other states have followed the example of New Jersey in adopting the important provisions permitting corporations to hold stock of other companies, and there are now few states in which corporations cannot be formed, which would be capable of acquiring and controlling the property and business of other companies. Thank you. The facts remain, however, that New Jersey is the state in which the greatest number of the largest companies are organized. It need not give the details of reasons why they are not organized in other states. In some, the state's fees on corporations are very large, like here in California. And the property represented by capital stocks is assessed for taxes at a higher value than similar properties of individuals. In others, there is a supervision of business and requirement of annual reports of the earnings or of the methods and result of the business. And there are some states in which legislation against trust and combination is distinctly directed against corporations, which in any way accomplish a similar result.
Stop right there. So as we can see, we know there's a separation of church and state. And we know that most of the communities that are within the state, i.e. County Bureau, village, city are not part of the religious society because there's a separation of church and state, right? So most of the property that's owned in the state by citizens of a state has no affiliation with the church. If it does, it's a 501c3. And the 501c3 is restricted. It has encompasses. It has duties, just like any other partnership, corporation, ECT, because it's not. It's confined to the state. The state is sovereign. That means that you just said that when it's time at the end of the year, you got to turn over your books.
Mm-hmm.
You got to turn over your bylaws. Everything you do, the state has a right to intervene in regards to an argument that comes on within a claim that involves parties. This is the reason why on the 501c3, in regards to an estate, it has to go before a court. Why? Because you're not arguing as a party of interest. You're arguing it as a trustee. Now, a trustee can argue as a party of interest if he's was authorized within the written express of the trust.
Mm-hmm.
And it says right there in the express trust 1606 that whenever there's a violation on behalf of the heirs and successors for spoilers, trickery, the only thing we got to do as trustees is put in a proclamation.
Mm-hmm.
And that's what we did. All right. So as trustees, in lieu of the estate that was taken, in lieu of the original grantees, which were the ones who will administer the state based on the beneficiaries who are truly the grantees.
Yep.
Because the grantee is the one in which the trust was established for, i.e. the beneficiary, which they switched places with us. So as you can see, New Jersey was the first state because as you know, New Jersey wasn't always called New Jersey because it was under the jurisdiction of the proprietors, which called it New Jersey. Prior to that, it was called Belwick of Jersey, which is the flag you see behind the King's Bench.
Mm-hmm.
All right, which was not a state, it was a state church. And it was not subject to any restriction because they're the one who determined the law.
Pablo.
And when I say the law, I'm talking about the common law of England. Everybody follow?
Follow.
All right,
Yeah.
continue on. CA?
Qualifying statement, like you said, each state is acting as a sovereign. So the fact that everybody is using New Jersey as their home base to set up their land banking is because they're afraid of being taxed and regulated like a real company is supposed to be.
Mm-hmm.
Mm-hmm.
Let's go back to land banking. As it said, you have to be down with, you have to comply. You have to comply by acquiring, paying your taxes, and going by the ordinances, rules, policies in regards to maintaining the equitable relationship that the state have with the corporation they allow to maintain the equity in regards to managing the assets, which is real property.
And
so remember, they can't own the land. They own the property.
So in layman's terms, what the king is saying is like they got companies like FHA doing business on behalf of the government, selling properties and such, and then they're not even giving you clear title, they're giving you cloudy title. I'll continue reading.
Well said, well said.
In view of strong expressions of popular and also judicial opinions against the combination of corporations for the control of industries, it is efficient that New Jersey must answer before the country for the policy by which she has permitted to be accomplished under the form of her law. Just like we said, everybody's going through Jersey to establish their land banking to subvert the rule of law in said estate. New Jersey must answer before the country for its policy by which she has permitted to be accomplished under the form of her law, as a result which has been regarded by the country and the legislator of many courts and legislators of many states as a serious mechanic to social
say that right. Say that
menace.
right.
Say it's a serious menace to the social and political welfare of the people.
Read that again. Now, this is coming from a lawyer.
New
This
Jersey.
is what the lawyer said about the state of New Jersey in regards to corporations.
New Jersey.
In view of a strong expression.
In view of strong expression of popular and judicial opinion against the combination of corporations for the control of industries, it is evident that New Jersey must answer before the country for
Hold on. It said the country. It said the country. It didn't say for the state, 2 states, 3 states, the colonies. It said the country. New Jersey got an answer for it. Go ahead.
And in view of strong expression of popular and judicial opinion against the combination of corporations for the control of industries, it is evident that New Jersey must answer before the country for its policy by which she has permitted to be accomplished under the form of her law, as a result which has been regarded by the courts and legislator of many states as a serious menace to the society and the political welfare of the people. I propose
that's social.
Social and political welfare of the people.
One second. Okay.
I propose, therefore, to trace briefly the course of the legislation and judicial decision in New Jersey which regard to business corporations, and to point out some of the reason why protections in her law and sought in the formation and management of the corporations which control some of the largest industrial and mercantile industries in the country.
Well, it's her law. It's due New Jersey laws that control some of the largest mercantile industries in the country.
The interest
in the country. So it's due her law that we can fix it.
Point of entry.
Because it said New Jersey got an answer, Archbishop.
And that's the only reason, and that's the reason why New Jersey have 16:1-28. It's the only, it's the only state that has that title, or as we see, you can't go to any so-called state to incorporate certain laws. You got to go to that territory that has those statutes. And in this case, as we read in all the land banks in this so-called country is getting their authority from New Jersey.
There you go. The lawyer can't make it no clear. If you don't believe the King's bench, ask this lawyer. Go ask, and I'm pretty sure you ain't gonna hire him. You're gonna come hire us. Why? Because we reiterating, like, how was the King's bench able to find what this lawyer is saying about something he's supposed to be defending? And he's telling you he ain't defending it because he know that there's somebody here that this belongs to. And he's telling you. And it starts right back in New Jersey. Go ahead.
And when I have done this, the question will remain whether the corporation thus formed under the laws of my own state are subject to the condemnation that has been pronounced against trust, and condemnation is restraint of trade.
In restraints of trade.
In restraints of trade. I cannot attempt to discuss the subject on the economic or political side, but I wish to consider briefly the legal principles on which the condemnation is based. I see whether they apply to the corporations which have acquired the property of rival companies, as well as to the condemnation made by means of contract which have been declared to be illegal as creation monopolies, as in restraint of trade. the policy of encouraging the combination of capital for the promotion of industries is not new policy in New Jersey. As early as 1791, when public-spirited citizens of New York, Pennsylvania, and New Jersey determined to form a company of the proposed of establishing manufacturers in this country. They came to New Jersey for their act of incorporation.
Read that again. Read that again. Wow.
As early as 1791, when public-spirited citizens of New York, Pennsylvania, and New Jersey determined to form a company for the purpose of establishing manufacturers in this country, they came to New Jersey for their act of incorporation.
Wow.
It was through the influence and exertion of Alexander Hamilton that the plan was devised. It was part of his plan of making a single and self-containing nation of the several states. The charter was drawn, or at least revised, by him on November 22nd, 1791. The legislature of New Jersey passed an act to incorporate the contributors to society for the establishment of useful manufacturers. The authorized capital was $1 million, and the company was empowered to hold property to the amount of $4,500,000 were subscribed, and over 200,000 paid in. The capital stock name.
He's still old. It cost 5. He only had 2 million, so he owed 3.
Unpaid debt put upon the citizens, national debt. The governor of the state was authorized to subscribe in the name of the state 4 shares to the amount of to be held for the purpose of raising $100,000 more. The society was forbidden to go into general trade, but it was authorized to dig navigable canals and deepen rivers with powers of condemnation, and given the right to take toll, and provisions was made for the incorporation of the inhabitants of such district. One second, qualifying statement. So they're saying they moved next to some already free inhabitants, built canals and flooded. This is when all the flooding was going on, where they flooded the territories and stuff and created new cities and societies next door to them. And these new cities and societies were municipalities, townships, and corporations, corporate in their construct. So they were basically flooding people out and then create new cities where everybody had to move to, and they were now governed under a business or a corporation. Wow.
And you have it. All that Katrina stuff, blase.
They've been doing
that.
They've been doing Katrinas on different territories. And they Lake Lanier, Katrina, different towns all throughout this country. You see flood stories or towns that have been flooded. But here, while they're describing, let me go back to the reading. The society was forbidden to go into general trade, but was authorized to dig navigable canals and deepened rivers with powers of condemnation, and given the right to take toll. And provisions was made for the incorporation of the inhabitants.
You hear that? Incorporation of the inhabitants.
Yep.
The Township Act.
Taking you off of one ship and putting you into a whole nother ship.
Yep. of said districts not exceeding in the area of 36 square miles as the society should select. And this district was to become a town with a mayor and alderman, and was to bear the name of great lawyer William Patterson, who took part in the framing of the Constitution and the Judiciary Act of New Jersey and the United States. The site chosen was on the fall of Passaic was the site Passaic. Okay, the site chosen was on the fall of the Passaic, and the useful manufacturers of her silk mills, her ironworks, her locomotive works have contributed very large to the development of the country at large.
You got your lemonade, right?
And no neglecting political and legal affairs, she has lately given to the country its vice president and its attorney general. It was not until 1846 that any general act was passed for the formation of business corporation. And this again was an act for the encouragement of manufacturers. Special charges were granted by the legislators to companies for various kinds and general acts. General acts had been passed providing for the incorporation of charitable and religious societies. There were statutes passed in 1817 and 1829 for the protection of creditors of incorporated companies. An act was passed in 1846. An act was passed in 1840 to prevent fraudulent elections, and there were various other general acts for the regulation of corporations. But the Act of 1846 was the first to make general provisions for the aggregations of capitals for aggregation of capital for the purpose of carrying on businesses without personal liability. This act is the basis of the statutes, but statutes that
under what?
Okay.
Am I too far?
He's right here.
Oh, sorry.
That's good. This act is the basis of statutes under which business corporations are now organized in New Jersey. The scope of the act was extended a little in the revision made in 1849. The stockholders were relieved of joining several liability for the payment of the whole of the capital stock. The object of the corporations might be formed under these acts were limited to manufacturing, mining, mechanical, and chemical businesses. It was required.
All right, I'm sorry.
Can we do it?
Yeah.
Right there, you want to follow. Okay.
It was required that statements of the debt and its assets should be published annually. No debt could be contracted beyond the amount of this capital stock, and stockholders were made liable to repay any part of the capital that might be within drawn. Directors were held liable for debt if they failed to file statements of the payments in the capital stocks. The businesses of the companies must be carried on within the state, and the meetings of the directors as well as the stockholders must be held there. But it was not required that any of the directors except the president should be resident of New Jersey. Careful provisions were made for the regulation of elections, and power was given to the Court of Chancery to appoint a receiver and distributor the asset in the case of insolvency. It was assumed in the legislation that the activities of the New Jersey Corporation could be confined within the state, and it was not until 1865 the express provision was made that any company organization under the general law might carry on the part of its business outside of the state and have one or more difficult offices and purchase and hold real and personal property outside the state, on the condition, however, that the statement to that effect were made in certificate of incorporation in 1886. So basically,
stop. So it must be expressed in the trust.
In the ledger.
There's not an express trust. Ours is express trust. The only way there is determined by way of the legal language in the actual instrument. Whereas though ours is, even though it's a legal instrument, it's an express trust left based off the verbiage prior to us even coming up on the scene. All right.
And y'all, please excuse my reading. I really need to, seeing small things and my eyes jumble around, it gets kind of wicked. So
don't worry about it, Noble.
Excuse the flow of the reading. Careful provisions were made for the regulation of the elections. Okay, I read that part.
1856.
It was assumed in the legislation that the activity of New Jersey Corporation would be confined within the state, and it was not till 1865 that express provision was made that any company organized under the general law might carry a part of the business outside of the state and have one or more offices and purchase and hold real property and personal property of the state, on the condition, however, the state that affected were made in a certificate of incorporation. In 1866, it was declared that the dividend of the accumulated profit, reserving and working capital not exceed half the amount of the capital stock should be made every year. And in 1872, it was required that the list of officers and directors with the resident of each should be filed annually. During all this time, a special charter had been freely granted by the legislator, and companies of every kind had been formed.
Stop. Right here, let's go back to Township Act.
On the benches now be our 30 minutes.
Okay. We come to our closing too. Where's it at? Township Act.